Hey everybody, welcome to today's live stream show. Today's special guest again is law professor Joe Potuto. Professor Potuto, thank you so much for coming on again. How are you doing?
I'm fine. Thank you for having me.
The biggest news in Donna Adelson's case is her recent motion for rehearing. So let's bring that on the screen. And Professor, have you had time to read this?
I have.
I assume so, because you're always well prepared.
Thank you.
What are your general impressions of this motion?
Well, I'll start, if you'll indulge me, a little before this motion. I have been consistently underwhelmed by the way these two lawyers present arguments, both orally and in writing. And after I read this motion where they say, trying to be polite, that the appellate panel misunderstood the heart of their claim, I actually went back and read their original amended motion. And you would have to be a mind reader to be able to figure out what the heart of their claim was from the original motion. I remember at the time when I read it thinking, this motion is silly. Judges always hear petitions for search warrants and other things, and then they preside over the trial. And I remember saying at the time, if they're arguing that there should be a different rule because this is a different case, and therefore it would have been easy for the state to go to a different judge, I still think that's not a winning argument, but it's a little better. But they didn't make that argument clearly at all. And I stand by it. There's nothing in that amended motion that comes close to what they say is their claim. I believe them that that's their claim, but they wasted a lot of time in the other one. It's appalling to me that lawyers can be this imprecise in trying to make an argument. So that's where I start.
Okay, thank you.
You're welcome.
I was watching STS on replay. Did you see that recent episode where they had this defense attorney named Jessica Mashali, who
Yes.
was, very strident? I mean, you gotta,
Yes.
Give her some bonus points for being that zealous advocate who is going to fight for the little guy's rights. But ultimately, it sounded like her argument was that, like Donna is going to feel like the judge is biased against her. And
Yeah.
I'm like, so what? I think all criminal defendants feel like the judge is biased against them. But ultimately, it's up to a jury to determine whether she's guilty of the charges.
Right.
It's not the judge who decides.
No, and some of the arguments that were made there by her, again, I found just at best unpersuasive. The claim that all prosecutors will play fast and loose to try to unduly influence a judge when she's sitting on a panel with two former prosecutors just seemed to me to be, unless she's saying, hey, the two other people on this panel are just willing to be unethical, it just seemed to me to be the wrong place to be making an argument. Judges put that aside. And I will say the argument that she made, I also found not particularly compelling. I mean, the claim was the judge will be prejudiced against my client, or at least my client will think that the judge is prejudiced against her because the judge had information that is false. Well, in the first place, in this brief for reconsideration, they assert that some of the information is false, but they don't really provide information substantiating that it's false. Now, maybe there are other documents that were filed under seal that we haven't seen, but there's nothing in this motion that demonstrates why they assert the information is false. But assuming they're correct and the information that was put in the warrant application is false, so it isn't true that they assisted Donna to speak to Harvey by giving her their cell phone. So what's the harm then? The judge will now know that that information was not correct and they didn't do it. So how is it then that he's going to be prejudiced against Donna?
Yeah. Well, I guess maybe this appellate attorney is arguing that the judge can't help but now have a negative impression of Donna's lawyers, which will in turn make him more, harsher on them in his rulings.
But if the information is unsubstantiated, you have to assume that the judge is going to say, hey, the state made a claim that isn't true, and now I suspect these lawyers. If anything, you would think he would be a little less happy with the state side, for doing the warrant application and having all this stuff go on and then nothing comes of it. I just don't see, maybe somebody in your chat or you can see where this prejudice is coming from. I just don't. And the other end of it is, if indeed they gave her the phone and she used it to talk to Harvey, and they shouldn't have the phone in the jail to begin with, I have a little trouble seeing how they can stay on the case, particularly if, I watched that STS episode, and I think it was Tim Jansen who said, it's a crime here if you bring in a phone into the jail. And I don't know Florida law well enough, but if that's true, then it seems to me that there's at least an issue whether those lawyers should stay on the case. Now, I certainly don't want them to be taken off the case, because we were looking at another 8 or 9 months before this trial goes. But so I'm going to assume they're right. The information was not correct. They didn't hand the phone over, and therefore no harm, no foul.
Yeah. So is that something that should be coming up at the case management hearing on June 11th?
Well, if they have to wait for the appellate panel now, or the court en banc, to decide whether they're going to take it. Until that happens, there's nothing Judge Everett can do. If the appellate panel takes it, that's going to be a delay in the trial. I assume, I'm not sure about this, it may be possible that Judge Everett can hear some motions. I think it's probably a little more likely that he won't, and then there'll be a delay until the appellate court en banc, or the panel, if it's going to reconsider, decides whether Judge Everett needs to be recused. And then if he needs to be recused, I'll have to bring another judge in. So there could be a delay until the appellate court decides one way or another on this latest motion.
Yeah, that's right. You just reminded me that this is with the Court of Appeal.
Yeah.
So it's not anything that Judge Everett has anything to do with.
No.
Not in terms of ruling. Yeah. And for the people out there, en banc, that means the full panel of Court of Appeal judges.
Right. What happens is, usually it's after a trial. This is the kind of motion you can hear before the trial happens. But you go to a panel of appellate judges. There are 3 on the panel. They decide. Usually then, whatever they decide controls in the case. Here, what Donna's lawyers are arguing is that the panel should reconsider its ruling because the panel missed the heart of their claim on the appeal. And then they say, in the alternative, it should go to the full court. What that means is all the appellate judges in the first district, I think there are 15 of them, should sit as a group to hear the argument that the panel of 3 denied. So when you go to, and that's an extraordinary thing for the panel to sit as a group of 15, you've got to show something that's exceptional about the case. You almost never get an en banc hearing. And you start out in any en banc hearing with the panel judges, unless they're going to rethink what they did. You've already got votes against you on that en banc hearing. So 15, assuming the court would take it en banc, it's already 3 on that en banc panel, or on the en banc court. that are going to be voting no on the reconsideration. But I think it's very doubtful that the court would take it en banc, because I don't think the arguments that are made are particularly strong. And you have to have you have to be, but it has to be more than strong. There has to be something exceptional about your case that requires it. A matter of constitutional magnitude would be one that would move a court to take it en banc.
Okay, but it sounds like Donna's appellate attorney is arguing that this is a horrible travesty of her constitutional rights, and she's going to have this biased judge on her
Well,
case.
you have to assume that the judge is biased, and if in fact they didn't hand over the phone, and you tell the judge that, the judge will know that it didn't happen. So I still don't see where the bias is. I mean, what he's going to know is the state thought maybe there was something there, and now he knows that the state was wrong and there's nothing there. How that reaches bias that would mean the judge can't be fair at the trial is beyond me. Maybe you or somebody in the panel can see it, but I don't. I don't see where it would reach that level if they didn't do anything.
Yeah, so similarly, can you address Rosemary's question here? Shouldn't the defense lawyers be recused for tampering with evidence, aiding and abetting?
Yeah, well, Rosemary, that would be, that's the other end of this. If in fact, the factual claim that seems to have been made in the affidavit for the warrant, which was that the records, the first warrant, which was just for communication records, there were a couple of requests that were made by the defense, by the state. The first one was around December 19. That one was communication records of Harvey. And that means a list of the phone calls, or might have been emails also, but a list. That's all it would be. They got that, and then they went back in and asked for a warrant to get a pen register and what is it called? A I'm not going to remember what it's called, but in any case, the pen register is, you get it's not what the calls were. You don't get to know the substance of the calls, but you get to know which phone number made the call. Or no, it'd be going out. Which phone number you phoned out to, the date and the time. The trap and whatever it is, it'll come to me in a second. Maybe somebody will remember. Is the other way around. It's like a pen register in reverse. It tells you which phone call called your phone and the time and the day. There you go. Thank you, Bichon Mama. Trap and trace. So in the warrant application, the investigator said that they had been able to identify that the phone number from the lawyers either was phoning Harvey's phone or vice versa, and that some of the dates and times corresponded to jail records when the lawyers were in the jail visiting Donna. That's the claim that they made. That the defense says never happened. It's not true. And the only thing I can imagine is what they're saying is it's true, it is true that they made phone calls to Harvey, but that they did it, that they didn't hand Donna the phone or convey Donna's information, act as a conduit between Donna and Harvey. At least I don't know what else it could be, unless the records that the state came up with between the trap and trace and the pen register was somehow wrong, or that the jail records as to when the lawyers were in the jail was wrong. But those seem to me just documented in documents. It's not anybody interpreting them. It's here's when the phone call from the lawyers went to Harvey. The trap and trace shows that, and the jail records show that one or the other of the lawyers was in the jail at the time. It's hard for me to see how there can be a factual mistake there, but I'm willing to hear it at least. But that's the claim in there. Now, if indeed, now this gets back to Bishon's mama's question. Sorry, Bishon mama, that took me so long to get there. But
Or is that
if,
Rosemary's?
yeah. Oh, was it Rosemary? Sorry. If indeed the records are wrong, then there's no tampering. There's nothing, because in fact, there were no phone calls made at the time they were in the jail, either to Harvey or from Harvey. And then there's nothing. The lawyers didn't do anything wrong. There's no record that shows them doing anything wrong. If it's the other, if those records are correct, then there's at least the possibility that they're saying, it isn't as though we gave Donna the phone, we were talking to him on the phone. Now, if you believe that, there's again, I don't know that you can say it's tampering or doing anything illicit, if you believe them. The way that it becomes a problem is if indeed they gave the phone to Donna, which, as I say, I don't know Florida law, but I did hear Tim Jansen say that's a crime in Florida. I also believe, Judy, and I tried to confirm it, but wasn't able to get an absolute answer, that even lawyers are not permitted to bring a phone into the jail. Now, if that's true, I don't know how they got the phone there.
Yeah,
if they had a
that's
phone.
what Tim said.
Yeah.
Yeah.
But then the question is, how were they able to do it? I mean, they've got the metal detectors at most jails, unless lawyers don't have to go through it. So I don't know how the phone would have gotten into the jail. So it may be that they had the phone there, they didn't bring it into where Donna was, but they talked to Harvey before they went in, or they talked to Harvey before they went out, and then again, there wouldn't be any problem. If they were able to get the phone in, this is like a tree with branches that go all over. If the jail made an exception, which the jail could certainly do, then there was nothing wrong that they did. If somehow they were able to get the phone in against the rules, and got it there, then they've done something that's wrong. Whether that's the crime, and I'm not quite clear, then they've done something. But then you get to, should they be disqualified from the representation because they did that, or does Donna's ability to choose her lawyers override? And one of the lurking issues here is, if they did it and they can stay on the case and she's convicted, whether there's a potential conflict of interest claim that can be made, that because they had done it, it somehow would have affected, a cross-examination, or they might not have put a witness on the stand that they might have put on the stand. I mean, then you're back into whether another issue will raise its head after the trial.
Yeah, it just seems like the case gets more and more complicated. Who would have thought? But I guess this is what happens when the client has tons of money to
Yeah.
keep paying the lawyers.
Yeah.
Yeah. What about this question from Eric? Could they have brought in a burner phone and also given Harvey a burner phone so they could talk?
Well, Eric, first of all, that's not the claim in any of this, because they had Harvey's phone number and they had the lawyer's phone numbers of their actual phones, not a burner phone. So it's certainly not a claim in any of this. This gets into how well the jail polices whether a phone can get in and whether lawyers go through the metal detector, and those are factual questions that are, it's theoretically possible, but you would think that the jail, doesn't want those phones in there and would do something to keep, from somebody being able, even a lawyer, from being able to get a burner phone in and give it to a client. And that clearly would be, now I don't think there would be any issue as to whether you've broken the law. But again, it's not the claim in their motions that's what the state was, the claim of the state that's what the lawyers or Harvey or Donna were doing.
Mm-hmm. And what about Bifcar's comment here? Put Donna's lawyers under oath and ask them what they were doing with the phone. Is this something that Everett could do, or would this have to take place with a Court of Appeal hearing?
Yeah, this one is a question that I'm not sure I can answer. If they were prosecuted for it, obviously, they'd have to testify. They'd be the only ones who could give information. if they're going to make the claim, they make the claim that factually it's not correct. And typically, judges would not put a lawyer under oath. If you make a representation in court to a judge, the judge is going to accept that representation. So I think it would have to get beyond, would have to get much more adversarial in terms of what was going on before that would occur.
Yeah, it seems like there would have to be some sort of outside proceeding against
Clearly.
the attorneys themselves.
And we don't know what, I mean, as I say, all you can see in the motion is their claim that the state's claim about the phone being accessible to Donna is false. But I've read that motion twice this afternoon. There's nowhere in there where they say why it's false or what's false about it. And in fact, it could be false that they gave it to Donna to use, but not be false that they had the phone with them when they saw Donna. I mean, it's that they're just not clear about it.
Yeah, which makes it kind of a little bit shady, for lack of a better word. It's like, where are the details?
Yeah, well, I would say that they just don't make their arguments very well. I mean, I've heard them do it a number of times. I mean, they say in the second motion, yeah, we agree that typically for an application for a search warrant, a judge can issue the warrant and still sit on the trial. I mean, but that's how that other motion should have read. They should have said at the start, we agree that in the normal case this is okay, but our case is different because. That would have clarified where they were. They at least as I read it, they didn't do it that way. They didn't do it very well. So I'm more than willing to believe that there's nothing shady. It's just one, I don't think they're very strong on the law, and two, they're not very good about writing what it is their claim is.
Okay, that's kind of a blunt assessment, but thank
Well,
you.
you know this, Judy, I'm sure. It's maybe some of the people in the chat don't, but one of the defining differences between academic lawyers who have not practiced at all or much and practicing lawyers is practicing lawyers tend to be more courteous and more careful. I mean, not careful, but more courteous in how they deal with other lawyers and how they evaluate the performance of other lawyers. And academic lawyers, law professors, tend to be blunt and people might say rude.
I don't know if I'd agree with that. There's plenty of rude practicing lawyers that I've run into. Well, not a lot,
but I
there
don't
are
hear you
some.
saying there are any polite law professors, so one half of it is true.
But they're polite law professors. Yeah, isn't the stereotype that professors are kind of full of themselves and pompous because the students don't talk back to them? That's my assessment, having been married to a law professor. No, just kidding there. Don't people unsubscribing, those few law professors that actually watch this channel. Yeah. What about this question? Could the lawyers have Harvey on the speakerphone? Well, that's still against the rules.
Yeah, it would be. I mean, the rule says you can't have a phone in there and you can't facilitate a conversation between a prisoner, somebody in the jail, and someone outside. Then using the speakerphone is just trying to circumvent the rule. And I'm confident that if that's the claim you made before a judge, that the rule only says you can't hand the person the phone, that you wouldn't prevail.
Okay. Here's a totally different question here. Misdemeanor says, do you ever have older people come to your classes as auditors? Often schools allow the elderly to sit in for free.
Yeah, most law schools will allow somebody to audit a class if they've got an interest, and there's room in the class. I mean, sometimes you've got a full class and it won't happen, but yeah, and if the underlying sort of thought in there is that misdemeanor OG might find it interesting, I think it would be. Judy may disagree, having gone through it. I think it would be interesting.
Sure, I never heard of someone doing this though, but I'm
Yeah.
sure it's possible if you
Yeah.
ask politely. Yeah. Let's see. So
I always
Susan,
used to say, by the way, you can come in and audit, but I expect auditors to also do the work and respond to questions.
oh,
I think
that'll put them on the spot. They'll say, never mind. Yeah. Plus, as a professor, like, wouldn't you see that as more work? You know, you don't want some like talkative older person disrupting your class, for
Well, but
example,
a
when
law
you're,
professor can handle if they're doing too much. I never thought it was a lot of work. I think students should be involved, ask questions, argue if they have a different opinion. That's how you learn. You don't learn just by sitting there like a little potted plant and take it all in and never think about the information you're getting and whether you think there's an alternative argument, a better way to do it. I mean, so I always think it's really terrific when you've got students who are active in class. In fact, that's part of the underlying reason for the Socratic method, to make you participate in class.
Mhm. Okay. And getting back to this Donna Adelson situation, this is kind of asking you to guess, but uh, what do you think this confidential informant did, or
Yeah,
what
I
that person knows?
I think from the motion, and you have to guess some because the motion doesn't give you all the background. But from the motion, it sounds as though the informant came forward to say that he or she, I guess it would have to be a she if it's the jail where Donna is, that she uh, knew, and we'll have to talk about how she knew, that Donna was communicating with Harvey through her lawyers. Now, how that would have happened, the informant could have said, she had seen it happen, or she heard it happen, or Donna told her it happened, or she overheard something that Donna said. How that informant would know, we can speculate, and Susan Hicks' guess is probably better than most because we know Donna is very chatty and doesn't seem to be able to keep things to herself that should be kept to herself.
Okay. What about another question from Rosemary? Wouldn't law enforcement have the records of the phone calls of Donna using her attorney's phone? Well, wouldn't that be on a separate line that they can't record?
Well, but that would be if the attorneys are phoning her from
Oh,
outside, right?
okay.
What they're claiming is the phone was used while the lawyers were in the jail with her. So you wouldn't have the phone call out. Um, what the investigators did was to confirm or demonstrate, although as I say, the defense seems to be disputing it, that Harvey's phone records show that there were phone calls made by his phone number to the phone number of one of the lawyers, and phone numbers apparently from one of the lawyers to his phone, and that those phone calls took place while the jail record showed that the lawyers were at the jail. So that's how they did it. And that's how they got to the claim that there were phone calls. Now, they couldn't say what the phone calls were about because they didn't have a wiretap. Later, in February, the second warrant was in January. The first warrant was, give us the communication records that Harvey has. And they would have gone to Verizon or AT&T, whoever his telephone service was with. Then the second warrant was the pen register and the what was it called? Trace and catch, whatever it is. I'm never going to
Trace
remember
and
that.
track or
There you
something.
go. Then they went for a third warrant, and the third one was a straight wiretap order to take Harvey's conversations, and that went to a different judge. That did not that warrant application didn't go to Judge Everett. It was another judge. Um,
Okay, so people are saying in the chat that it was an Apple Watch that was being used as opposed to a phone.
Ah, well, these
I don't
people
even
are
have
very
an Apple Watch.
I do.
You
And you
do?
can get phone calls in. I didn't know that you could phone out on an Apple Watch, but I'm hardly the techie in the world. That's certain that well, that's at least more possible. That would be a better an explanation. If the allegation is true, that would be a better explanation of how they got the phone, or at least the phone availability, into the jail where Donna was. So your chat people, your people on the chat are very smart. Not
Yes, yes,
surprising to me at
yeah.
all, but yeah.
Yeah, I also recall an Apple Watch being mentioned in one of the
Does
filing.
anybody know? Can you make a phone call out on? I wouldn't know what to do to get it out, but you can certainly get a phone call in. That I can
Okay,
swear
let's
to.
scroll down in the chat and see. Okay, anybody have an Apple Watch? Okay, thank you, Madeline. Bullet. I think that's really her last name. It's not that she's
Huh.
poking fun at Bullet Bourbon. Okay, or Bullet Rye Whiskey, but this is a cool name you have, Madeline. The Apple Watch has a separate number for Verizon, not your cell phone number. Okay, and it says if the Apple Watch has its
Has
own
its own
SIM card.
SIM card. Ah,
Oh, mm,
I didn't know you could get a SIM card. Well, uh, that being
yeah.
true, that explains how it could have occurred. Uh, in a better way than I, because I couldn't, it's hard for me to believe how they could get the phone in, but that explains it.
Mhm.
Ah,
Yeah, and Rosemary also asked, wouldn't there be some sort of hearing about the misconduct? So that could be going on behind the scenes
it could,
regarding the
or
attorneys, right?
it
But we
it
don't know.
could, or the state didn't go forward on any of this. They said at that hearing there were no new charges that were being made. Um, I don't know whether Donna's lawyers provided their explanation once they learned of the warrants and the state accepted the warrant. We just don't know. The general question, whether it would be going on now, um, really, I think more relates to whether there could be charges or would be charges brought against the lawyers. It's kind of peripheral to this trial. Uh, if Donna talked to Harvey, if they don't have any information that it led to anything, and it doesn't look like the state is going to use it at trial.
Okay, so I think I skipped some questions. We'll try to address them all. Isn't a judge responsible for issuing warrants? Yes. Wouldn't he be the one responsible in agreeing to issue all the warrants? Yeah. But it sounds like they can also go to other judges, right? They didn't have to go to Judge
Yeah,
Everett.
right, right. Usually you go to if you're doing a trial and you need a warrant, depends on the jurisdiction. In New Jersey, for example, there is a judge on the court in each county that's assigned the responsibility to issue search warrants. So he's the one or she's the one who does them. You always go to that judge. In other jurisdictions, Florida sounds like one of them. You could go to any judge, and I think typically they would go to the judge who's hearing the trial, who's going to be sitting on the trial. But you don't, that judge might be on vacation. Somebody else might be sitting in. In this case, knowing what they were looking for, maybe the better part of wisdom would have been to go to a judge other than Judge Everett. Although, as I recall, I heard Tim say he was also the administrator, I don't know what we called him, but essentially the administrative judge. He would be sort of the backup, you know, if you needed something and your judge for your trial wasn't there. So that would make it more difficult. But I'm not so sure. I mean, I was trying to think about this. I think it's absolutely a sure thing that the investigator, when they got the information from the informant and decided they needed to pursue it, and decided that they needed a warrant to go after some of the information, that they would have gone to the prosecutors. They wouldn't have done it on their own. In fact, in New Jersey, you can't do it on your own as an investigator. You have to go to the prosecutor's office. You have to have a prosecutor. Actually, the prosecutor would write the application for the warrant, and you have to have the prosecutor accompany you to the judge to get the search warrant. Again, doesn't sound like Florida puts those requirements in, but it seems to me in a case like this, the investigator would have gone to a prosecutor. The prosecutor would have said, yeah, this is something that needs to be investigated, go ahead. But whether they then would have keyed in and said, well, what we're looking at, might show that the lawyers were doing something they shouldn't have done, and maybe that would bias the judge against the lawyers, and that would in turn bias the judge against Donna, and that would have an impact on her trial, and therefore go to a different judge. I think that's probably a lot to expect lawyers to be thinking of when in a busy day, when they've got lots of other things they're doing, to sit down and think it through. I think after the fact, you can say, gee, it would have been, maybe smarter to do it that way. But I think it's a lot to expect that on the front end, somebody would track through all those stages and tell the investigator, don't go to Judge Everett, go somewhere else.
Okay. Yeah, I just clicked on a comment here. Wasn't it that somebody claimed that Harvey had power of attorney? So, I mean, that seems kind of goofy, because obviously having power of attorney
doesn't make you a
you're
lawyer.
real
No.
attorney. Yeah.
Power of attorney just says you can sign for me. It doesn't say you can represent me at a trial.
Yeah, or there's some attorney-client privilege.
Yeah, that's right.
Somebody, I think it was Turquoise Kitten, wanted to know, does Wendi still have an active license? Yes, she does. She's still a licensed attorney in good standing with the Florida bar, and she uses a P.O. box in Miami for her bar address. So that's public info.
So she's not practicing in Texas then?
Well, my guess is that she is not practicing because she's probably so fixated on getting ready for her mom's trial, and she has plenty of money from her family, plus, those Social Security benefits for her kids.
Boys, yeah.
So she doesn't really have to work, but since she's licensed in Florida, she could still technically practice immigration law, even if she's in Texas.
That's true, yeah.
So it's, let me try to scroll through to have some more questions for you. What about what we have on the screen here, where the appellate attorney is saying, well, that's not fair, that we weren't there to be able to bring up the informant's horrible criminal record.
Yeah, that's the most ridiculous argument that was made. It is impossible that if you're going to go for a search warrant, and even more so if it's a wiretap, that you should alert the defense that you're going. Because if I'm alerted that you're going to come search my house and I have something in my house I don't want you to find, I'm going to get rid of it before you get there. And if it's a wiretap order, I'm not going to do anything, going forward that's going to be incriminating. What they claimed was because it was a different case, the judge should have heard them. And there is, I've said that, but there is something, the argument, although it's ridiculous in the case of you should alert and then have a hearing, so it's not ex parte when you're going for a search warrant. That's ridiculous. But there is some merit to the claim that since Everett knew, because of the 2 warrants that he signed, that there was this investigation going on when he did the bond hearing for Donna, when she wanted to be released on bond, and he made some claim about, you've been interacting with your lawyers a lot. They translate that to mean he was relying on the evidence from the warrant. I would say he would know that she'd been interacting with their lawyers. They were going to, remember the original trial date was going to be February, wasn't it? And they were rushing to get ready. But
Or
I do
June.
think, I do think there's some merit to, if you, maybe a lot of merit actually, that if you're the defense lawyers and you're making a motion and you don't know that the judge has information that might make him suspect that your client is trying to collude to have somebody testify, perjure himself or do something else, that would be relevant, because at the bond hearing, the issue is whether you might tamper with witnesses, in addition to might you flee. But it seems to me that the evidence that, after she tried to leave the country and go to Vietnam once, was completely enough by itself to for the judge to say no bond. And you could fix that one by having a bond hearing now. Bring it before another judge and see if that other judge would let her be out on bail while they're, doing the case. And that takes care of that issue. But I think that's the only place where this has some potential merit, that the judge had information that the defense lawyers didn't have, at least at one of the motions, maybe more than one, and the information arguably might have been relevant to the decision that the judge made, but the defense didn't have a chance to confront the information. On the other hand, the judge knew that it was coming from a jail informant, and the judge knows that jail informants have a criminal record, and the judge knows that jail informants are notoriously not credible because they're willing to say anything, if, a lot of them, if they can get out. So that information, I mean, the judge is not a 3-year-old walking around. I mean, he's savvy enough to know all that, all that is true. So.
Mm-hmm. Well, what do you think about Attorney Mashali saying on STS that the judge should have recused himself right away as soon as he got wind of what this request for a warrant was about?
Yeah, I
think
disagree
that's
with
what
her.
she said.
Yeah, I just disagree with her. Yeah.
Okay. Well, she did get a lot of people riled up in the comments,
I
in the
didn't see the
chat. I don't
comments.
know
I
if
didn't
you
see
saw that.
No, because, I mean, to assume that a judge who's sworn to, to act responsibly and ethically, and to see that a defendant is treated fairly at trial, to assume that the judge is going to take, a piece of evidence and therefore the defendant's trial is going to be prejudiced. It seems to me that's a big leap, and certainly based on the evidence here. Where I would agree is, had the prosecutor and the investigator really sat down and thought through all of this, getting the warrant from another judge would have been would have avoided this entirely and might have been the better way to do it. But I still think that requires that you're really focused on one case and one issue and really thinking about it. And it's really easy on the back end to say, this would have been so much easier if this had been done on the front end. But I don't think once he sees the information and signs off at the warrant, he then should say, oh my God, now I'm prejudiced and I can't conduct this trial fairly, and now I'm going to recuse myself. Because I don't think it's true.
Yeah, I totally agree, because once again, he's not the person who's going to be coming up with the verdict in the case.
Right. And I would say, if you're going to try to think about, sort of shady dealings, and I don't want to say this here, but, I can certainly envision defense lawyers doing it, making these motions and saying, now you're going to be biased, in an effort to influence the judge the other way. Because now he knows that they've made this claim, and if he rules on a motion, or he rules on, an objection to evidence coming in, and it's against the defense, that the appellate brief is going to list all these things and say, see, we said this ahead of time and now it's proved. And it might make him a little more wary of ruling on objections in favor of the state. I don't think he'll do that either, but it seems to me it's at least as plausible a result from these motions and from the issuance of the warrants.
Mhm. And what about Tamara's question, are these shenanigans going to delay the trial? And Rosemary pretty much has the same thing, because isn't this going to deny her a speedy trial because of all these motions?
Yeah, well, let me take the first one first. Delay, since the appellate court is going to have to rule on whether they're going to reconsider, or whether the court en banc will reconsider. They have to do that. I don't think that, and I think that might be a week, 10 days. And I think that will delay the trial, because I think the Judge Everett can go ahead on, I mean, there's nothing of substance coming up for the next few days that I know of. If the en banc court decides to hear it, then they're going to have to set it for hearing, and that will slow it down. And then once they've set it for hearing, I don't think Judge Everett would sit on anything until they decide whether he's going to be disqualified or not. Depending on how long that takes, it might delay the trial a little, because I assume the defense lawyers will say they now need more time to prepare. So there's at least the potential there. But neither of those should delay it very much. And I don't think this will happen, but if Judge Everett is disqualified and a new trial judge sits, that trial judge can go. He doesn't need, or she doesn't need, much preparation. He's going to hear the case that's presented. So I don't think that will delay it. The thing that will delay it is if out of all of this, there is some showing that the defense lawyers did do something that they weren't permitted to do. And then the question would be, should they be able to continue to represent Donna? And clearly, if they can't represent Donna, we'll have a huge delay. Huge in my mind. I mean, I think anything more than,
Like a
2
year.
months is huge.
Yeah, that would be horrible. Well, mentor lawyer James did mention on Deep Dive True Crime that the state has 20 days from when this motion was filed to file their response.
Right.
So I don't know how quickly the Court of Appeal judges can react to such a motion, but maybe there's hope that they could have a hearing, say in July.
Yeah.
Then maybe the trial won't be delayed.
Well, I'm not
just
sure they'll
guessing.
have a hearing. They can just, on the appellate
Just
level,
say
they can do it
no.
on the record, on the submissions.
Mhm.
And if this panel could deny it quickly. I mean, I don't think the panel took much time from the original motion to disqualify Judge Everett. And there was nothing filed by the state. The panel just looked at it and said, the panel said this is completely meritless. So I don't know that the panel would need to take much longer. If it goes to the request for an en banc hearing, I don't know, the time that the first district would take to decide yes or no. If it's no, there'll be a little time while they have to schedule and decide they're not going to take it, but it shouldn't be all that much time. At that point, if they decide they're going to hear it, they may want the state to respond, and that will delay it a little. But Judy, those are the delays, in terms of defined times. It shouldn't be very long for all that to happen. I mean, but every day is annoying, to the state, and every day potentially pushes it back a little. So.
Yeah, that's just such a downer after all these delays.
Well, and because you've done trials, you get up for the trial. You're ready to go, and it's very deflating then not to be able to go. And all these witnesses are scheduled. It has a ripple effect on everyone. So yeah, and that's not to mention the Markel family, who it's got to be really extraordinarily troublesome, and to think that things are finally going to go, and then there's another delay, and there was another question. I don't remember who. I apologize. I don't remember who had put it on, but that was the speedy trial question. There's no speedy trial issue here because it's Donna making the motions. She's got a right to a speedy trial, but it's only if the state is delaying, in her eyes delaying, and she raises the speedy trial issue and says, I don't want any delays, you got to go. But if she's the one making the motion, she can't at the same time say, I'm entitled to a speedy trial. It would be like, well, not like, but think of you kill your mother and then say I put myself at the mercy of the court because now I'm motherless. You can't do both. I mean, you shouldn't do either, but you can't do both.
Okay. Now, Miss Demeanor wants to know, where do you teach?
Well, I'm not at the moment, so you can't catch me. I was thinking of doing something online, because that would be kind of fun. But right now I'm not doing. In fact, I was thinking I should do something on YouTube and do a little course on some of this because it's interesting I think would be interesting for people to have some background, but can't do it. I might be willing to do a few lessons on Zoom if you're really interested, Miss Demeanor.
Oh, that would be exciting. Can you imagine if you set up your own YouTube channel and then people might be willing to pay for a
Oh, they don't
course?
have to pay, no.
People's Law School.
Oh, that's right.
Maybe you could go for those people in California who want to sit for the bar without going to a real law school.
Well,
Like
they'd
Kim
have to know,
Kardashian.
but they'd have to know more than criminal law. And I would
Oh,
be
yeah.
willing to do maybe civil procedure. I can think of a few other
Constitutional
courses, but
law.
you couldn't get me into tax, and I wouldn't want to do contracts or property law. And at least the latter two you need for the bar. You don't need tax, but you're going to need contract and property law.
Yeah, and probably family law,
Yeah,
depending on
that's right. Well, you could do that for us, Judy.
Yeah, we teach family law to prepare people who want to take the bar
There you go.
themselves in certain states. Yeah. We'll create our own little
That's right.
online law school.
But,
Can you
but if
imagine?
there are people who want a little more background on one or another of the criminal law issues or, Fourth Amendment or something, I would be entertained trying to do that. I've got some articles that I've done on trying to make it, clearer and easier, although you don't get into the nuances, obviously. I think we should do a little more of that in the high schools, actually. So
Yeah, I
people have a
think
better idea of their rights.
that's right. Yeah, high school students need to learn the law. Yeah.
Right.
Okay. Well, I'm kind of behind with the chat, but Clarissa says this is the third time Donna is trying to get rid of Judge Everett. Why? She even hired an appellate attorney. What do you
Yeah.
think? What's your guess? Why is she
Well,
trying to get rid of him?
I guess I would say maybe because he sat on Charlie's trial and he's been through, the motions with regard to conflict and made her, lose her second set of lawyers and everything, that she feels a lawyer doesn't know anything about the case, would be more receptive to her claims than Judge Everett, who, after all, um, saw Charlie's trial and heard the arguments that Charlie made, and Donna presumably is going to come in with some defense that's a little different. So I guess I could maybe understand that. I mean, they may be looking for a more sympathetic judge. They may just think he's too smart and knows enough about the case that, any judge would be better than he is from their perspective. But it is true that she was gung-ho to go. If you remember initially after Charlie's trial, she wanted that thing to go, 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 go. And now all we're doing is filing motion after motion after motion and getting delay after delay after delay. It is certainly a reversal of, perspective from her.
Okay. What about this question? Do you think the DA will have enough to arrest Harvey for trying to bribe witnesses?
Yeah, well, I don't know. I don't know what they have. All we know is whatever the state decided they needed to investigate back in October, they said at one of the hearings this year that there weren't any new charges being filed. So that doesn't sound as though they found anything that would give them more evidence against Harvey than they had before.
Although I sort of wondered if that comment about no new charges just had to do with
Donna?
against Donna,
Yeah, could be.
not against people in general.
Could
But
be. But we
yeah,
don't know, you know. It would be
yeah, we
nice
don't
if
know.
they told us everything as they went.
Yeah,
But
that's why I thought that was pretty great that James' mentor lawyer got to, you know,
yeah,
sneak on in there and ask Georgia Cappleman a question real quickly after
yeah.
the court hearing, where
And
she
the
confirmed.
question, Judy, if you remember, was it was after Donna's lawyer said there was false information, and that's what mentor lawyer asked, and Georgia Kappelman said, we don't agree. So
Mhm.
that's why I say this generalization of there's false information, particularly if they didn't specify for the appellate court. Imagine you're sitting on the appellate court, you have a highly respected trial judge who says there's nothing here that leads me to recuse myself. And you make a claim to the appellate court that there's false information without telling them what the appellate court, you as the appellate court, what the information is. You know, you're saying you're going to give the appellate court a blindfold and then ask them to rule your way against a decision by a judge who's very respected. I mean, that doesn't seem to me to be a good way to make the argument. But I started out with this. I just don't like the way they do arguments, you know?
Mhm. Well, I don't know if this is just said in jest, but Ms. Demeanor says, can Lori Vallow represent Donna virtually? So the answer is no. There
Yeah,
can't
well, and from what I've watched of Lori
be.
Vallow the last couple of days, she certainly can delay the start of the trial and presumably keep the trial going longer than it need. So in that sense, she might be helpful, but she doesn't have a law degree either. She's not licensed to practice anywhere except where she's on trial, so.
Mhm. Whereas for actual licensed attorneys like Sam Zangenhay, he was able to get admitted pro hoc vice to
Ah,
defend somebody. Was it that Mulvaney trial, the Bob Lee murder? I think that was the case in California
ah,
where Bob Lee got stabbed to death, and Sam Zangenhay, I think, defended the I'm getting confused. The murder victim's uh, friend's brother who was accused of doing the stabbing.
hmm.
Okay. But anyway, that's like a whole other case. But it is possible for attorneys to go to another state to defend someone if you
If you
have
can
one
find a lawyer to
sponsor you.
sponsor, yeah,
Yeah.
yeah.
Okay. Hi, Dawn. Dawn has, if the defense lawyers get booted, then why would Judge Everett need to recuse? Wouldn't that potentially be used in the new trial with the new lawyers?
Yeah,
How would prejudice Dawn?
yeah. Let's hope there's nothing there and the lawyers are not booted from the case, but assuming that that happened, I don't think there would be a need for Judge Everett to recuse himself because the information with regard to, it would have to then be information that Donna uh, would seem to be information that Donna was attempting through Harvey to do something that shouldn't have been done. And if that's the case, that likely would come in a trial anyway. So I don't know that it would affect Judge Everett's ability to sit on the case.
Mhm.
But we won't know, until we know what it is that the defense lawyers are saying is false about that information about the phone at the jail. It's really hard to assess, um, the impact on Judge Everett or the impact on Donna or the impact on Harvey or the delay that might occur in this trial. As I say, my best guess is Everett will still sit. The court will not hear it en banc. The panel will deny the request for a reconsideration and will go forward. And presumably, there's nothing that the defense lawyers did that would turn out to be something that would they didn't do anything, or it isn't anything that would impact their ability to represent Donna.
So another question here. Was the district attorney suspicious of Donna's lawyers possibly behaving badly because of what corrupt Rashbaum did? I don't think whatever Rashbaum did would affect their view of her new lawyers.
Yeah, I agree with you, Judy.
Okay. Yeah, and plus these new lawyers, they've been in Tallahassee, and Fulford was a former judge, so they probably already knew these attorneys' reputations compared to
Yeah.
Rashbaum,
And
who's,
Fulford was in the prosecutor's office for a number of years, but she
yes,
also had an ethics, complaint against her when she was a judge, um, and evidently had an illness and was permitted to resign from the bench before the ethics claim was heard. So that's kind of her background. I don't know as much about, the other lawyer, Josh Selman, but they're certainly known in Tallahassee. That's certainly clear.
yes. Well, the attorneys that have shown up on YouTube, the ones that know Selman, they have all said positive things about him, that he has a good reputation and he's competent and experienced. Yeah. So let's see. What are the most common reasons why a judge would have an ex parte meeting?
Yeah. Ex parte is rare, particularly on the criminal side, and it's a little unfair to call the warrant application an ex parte hearing because applications are always ex parte. I mean, to call them ex parte makes it sound as though there's something unusual about the warrant applications here. They are always ex parte because you never bring in the other side when you're getting a warrant. It's just crazy. Even thinking about it, it's just crazy. What you do with a warrant is after the execution, well, at the time of the execution of the warrant, let's say Judy, I've got a search warrant against your house. At the time of the execution of the warrant, I give you a copy of the warrant, but then I search. You have no time to hide anything. You didn't know I was coming. With wiretap orders, you get a report of the application for the wiretap and a list of the dates of the conversations sometime after the wiretap ends. So on these sorts of things, they always are ex parte, and your notice is after the fact, so you know what it was, that was looked for and what they found. As to other kinds of ex parte hearings, they're extraordinarily unusual, but it's possible if there's something that's very private, doesn't seem to be relevant, sort of reputation, really bad reputational something, it's theoretically possible. But you've got to be in a civil trial. It could be, protected info, work information that you might have. It's that you don't want your rival to know about. So you might be able to do that ex parte. On the criminal side, if you're claiming that you don't have to testify or provide information because you have a privilege against self-incrimination, that one would be ex parte, because if you really have a privilege, you can't be compelled to talk about it, and the state shouldn't be able to know about it. But we can't just take you at your word that it's something that you can't testify about. So the judge has to hear enough to decide that there's a reasonable basis for saying you can't, this is information you can't be compelled to give. That would be the most, I wouldn't say common because it doesn't happen very often, but the most likely one I can think of on the criminal side where it could be an ex parte hearing.
Yeah. And on the civil side, what I'm familiar with are domestic violence protective order
Right.
cases where first there's an ex parte hearing where the person gets to go in almost immediately to talk with a judge. And if the judge finds that there appears to be merits, then there's ex parte order against the defendant, but they do have the right to have a hearing within 10 days.
Right.
Same goes with emergency child custody hearings where somebody is alleging that the other parent is about to flee the jurisdiction and take the kids or is abusing the child, then they can have an ex parte hearing. So, but it is pretty rare, yeah, in general. Okay, so I know we still have questions here. Thanks for being here. Daniel says, who went to Judge Everett to get the wiretap warrants? Was it a detective or was it prosecutors? Surely Georgia had to know there would have been a conflict. Well, Tim Jansen said it was Jason Newland, the investigator.
Right. And the first two were not wiretap orders. In other words, a wiretap is where I've got the authority to listen to your phone calls. And they did get a wiretap order, but that was the third time, and they went to a different judge when they asked for the wiretap order. The first two, the one was simply a list of phone calls. I'm not sure whether it was emails also. I was unclear from the motion, but all that was a list of phone calls that Harvey had made. That was the first one. The second one was the pen register and the reverse, which was again on the paper, but it allowed them to see, and I guess the whatever they do to find out where a phone call was made from. So it allowed them to see what phone number was used to make a call, what phone number received a call, and the general location of where the phones were that either made the call or received the call. Those were the two warrants that Judge Everett signed off on. The one that was actually the wiretap order, they went to a different judge. And I might add, what's replete in this motion, and I see it in all the things, well, I shouldn't say all, but in a lot of what the defense lawyers file, and Rashbaum before them, they take a factual situation and impute intent. And I just don't, again, I don't think that's a good way to write a brief. In other words, or let me give you an example. In the example of the warrant where they were actually looking for wiretap information, the lawyers say either Judge Everett recognized that there was a conflict, or the prosecutors, recognized and went somewhere else. That's possible, but it could also have been that Everett was on vacation and they went to a different judge to get it. They're constantly saying a factual situation was done with intent. When you can't show intent, you can say it's possible, but you can't show intent just because but here's the one that they did all through. They went to Judge Everett because they intended to have him be biased against the defense lawyers. Well, I suppose that's possible, but there are a host of other reasons or explanations, and it's just bad brief writing or arguing to say that there was an intent when all you have is a factual circumstance subject to a lot of different explanations. You're just adding more weight to the argument you have to make. In other words, you could say, this is what they did, and our concern is it will have the effect of biasing the judge. You don't have to say they did it with the intent to, so now you're accusing them of doing something, unethical.
Mm-hmm. Well, I have to commend you on your brilliant memory, because even I couldn't remember which warrant did Everett sign off on. You got to play trivia night someday. If Dawn and I do another Markel.
As long as I don't
night.
have to do geography. I don't do geography.
Oh, okay.
Or I do, I do geography. I do it really badly.
Okay. Well, Dawn, speaking of Dawn, she has another question. Do you think Donna's lawyers will be found to have violated the rules and done what the state is suggesting? 1 to 10. So she wants you to rate the likelihood.
I know.
But this is totally guessing. We don't know.
I know. Dawn, I am more than willing to take a position when there are when there are alternative possibilities. I don't mind going out on a limb, but this one is hard because we don't know what it is the information that came out of the warrants actually showed. I mean, if the information that came out of the warrant showed the phone was there, the phone calls were made while they were at the jail, then I would say, you know, the being found guilty to have violated the jail rules would probably be 10. The rule is you can't bring a phone into the jail, and they had a phone in the jail, or maybe 9, because maybe they can say they were not with Donna when it happened. But it's the hearing at which these, you know, different facts would come out. And it's just impossible to guess, at least for me to guess.
Yeah, it's tough because, you know, a lot of times lawyers do not want to be put in the hot seat and be wrong or potentially, you know, show some sort of negative bias against somebody or another lawyer. So when I was interviewing Chuck Collins, who is Luis Rivera's former attorney, it was hard to get him to answer questions because he didn't want to make conjectures.
Right.
He was like, I don't know, Judy, I don't know. I don't know, you know, but, you know, sometimes it's okay to guess for the sake of having a discussion, right? This is just our opinions. So let's see. Hi, Sandra. Sandra won one of our trivia nights. She knows the case like the back of her hand. Defense attorneys attempting to put Judge Everett on trial when they have unclean hands isn't going to work, not in our justice system.
Yeah.
Any comments to that?
Yeah, I mean, if the defense lawyers truly believe that the information that Judge Everett got in signing off on one or the other, the first 2 warrants, will lead him to have a negative view of them. In other words, that assumes that the information was correct and they say it was false. I mean, well, anyway, then, you know, in zealously representing their client, they're not only entitled to make the argument, but maybe they should be making the argument. It's just that the way they made the argument, I just think is not very effective. And it's also, now that I'm sitting here, inconsistent, because if you say there's no evidence to support and he's going to be biased because he thinks we did something wrong, those are directly conflicting statements. So.
Okay, I kind of feel like you addressed his question earlier, like what's your speculation on the real reason Donna's fighting so hard to get
Yeah, we
Everett
talked
off?
about that before.
Yeah.
Yeah.
Yeah. Well, I personally think that they do in a way, since the whole family has seemed to act as a unit to protect each other, that perhaps she just wants to buy more time because now Wendi has a whole summer with the children. So this is just the more it drags on, the more time Wendi has.
Yeah, but Judy, if that's true, why didn't she care about it a year ago? Why all of a sudden does she want Wendi to have more time with the children? I mean, last year she was hot to trot to get that trial going. Plus, I just have it. You are a mother and I'm not, so you are probably much better placed to assess this. But I just can't see why she would be so interested in Wendi right now, given that I don't think Wendi has been in touch with her, given that she was really angry with Wendi for not helping them when they were going to flee to Vietnam, given that Wendi has dropped Charlie, who is the apple of her eye. And if the issue is the boys, they're getting older and older. I mean, what are their ages now? 17, 16, and 14?
No, 14 and 15.
Okay. Yeah.
I'm pretty sure 14 and 15.
Yeah.
Yeah. Although, yeah, the oldest child will be 16 later.
Yeah, I thought it was
summer.
coming up to, yeah.
Okay. Well, see, your memory about this case is pretty amazing. You're right. Because remember when Marisol Toscazzo was all like hot to trot in court? She said, we're ready to have this trial. I'm like, really? Seriously? You know, like back in 2023?
Yeah. She just wanted to go. You know, so I said at one point, maybe she's decided she really likes being in jail.
I don't know. Yeah, who knows? Maybe she has adjusted and become a domestic coordinator there in jail in charge of the young girls that
Yeah.
she can manipulate and try to
Uh-huh.
get them to become her witnesses.
Yeah.
Yeah, that's a
It's
joke.
just peculiar. But if I were asked to um, assess her personality and why she does what she did, what she does, boy, there would be so many places where I could put a pin in the cushion to try to figure it out. This would only be one of a number of places to say, why is she doing this? Yeah.
Mhm. Let's see. There was a comment, totally different topic. Somebody wanted to know, is going to law school at age 60 too late?
No, of course not.
If you
In the
want to go, go.
Yeah, it's
If
a
you have the
great
money.
education.
Yeah.
I think can be a lot of fun. Uh, at 60, you can still, what you'd be at 63. There's still jobs out there. And they don't have to be necessarily jobs in law. There are lots of places where a law degree is helpful. If you're in a situation where you don't have to be formally employed, there are lots of places where somebody with a law background can be very helpful in terms of volunteer work. And I don't think 60 is too late to do anything.
That's right. 60 seems kind of young to me now. As we get older, it's like, wow, 60 is not that bad,
Yeah,
or 40 is
yeah,
great.
that's right.
You're only
I'm more
40?
I'm more likely to say 20 is too young to do a lot of things.
Yeah, that's right. Like today, I went to my bank and I saw these two young women there. I was like, wow, I feel so old. They look like they just graduated from college and they're
Mhm.
working at the bank.
And they
Yeah.
don't have, I mean, I don't want to disparage the young, but they don't have life experiences and sort of the broad kind of the wealth of information you acquire. So, I mean, if I had to pick between a 60-year-old and a 20-year-old to represent me in court, I don't think I'd have any trouble picking the 60-year-old.
Well, the benefit of being an older law student is that once you get out, people just assume you have lots of experience. Because when I was maybe like 2 or 3 years out of law school, I helped my firm hire someone who was in her late 30s because she had gone to law school for a second career. So I was training her to go to family court, but the judge just assumed that I was the one that was the trainee. And I was like, well, whatever, because she was a lot older than I was. But yeah. So, but on the other hand, when I first started this YouTube channel, I did a lot of like law school type of videos. And I was pretty negative about people going to law school, to be honest. So I think people do have to kind of weigh whether the costs of going to law school are going to be worth it, because we're just assuming the person can afford to pay for law school out of pocket. If you're going to
True.
have to take on tons of debt at age 60, I would probably say probably not worth it.
Yeah, that's true. The cost is out there. I would not disagree with. But the idea of going on and learning new things, particularly interesting things, it seems to me is a wonderful idea. I've been taking Italian for 15 years. You couldn't prove it by how much I can speak Italian, but I keep trying.
You're not in Italy now, are
No,
you?
I'm not. I'm not.
Oh, okay. Are you going back again soon?
In 2 weeks, I'll go for 2 weeks.
Wow. Okay. So a lot of going back and forth then.
Well, this time it's a family trip. We do it every 2 or 3 years. And I
Oh,
recommend it to anybody on the chat who has the money to be able to do it. You don't have to go to Italy, but going with your family somewhere where you're away is a great, it allows extended family to really, get to know each other again. And it's great bonding because they can't go off and do something else. So, you're sort of push towards family time, which I think is really, worth doing.
oh, didn't you say you still have like a distant cousin in Italy that you keep in touch
There's a
with?
part of my mother's family that's still in Italy. I've got closer cousins in France because
And
the town my parents were born in, they both were born in Italy, uh, was extremely poor in southern Italy. And so people in the town emigrated all over the place. So there are lots of places in South America where I have relatives in the French West Indies, and the group in France started in the French West Indies and went to college in France, and now they have families in France. So, yeah. Um,
oh, that sounds very exciting. So once again, if you do a YouTube channel, you could do one about Italy, the culture and the language, and
I think
show
that's too
people your
eclectic, don't
voyages.
you? I think you have to have a shtick. You can't say,
Yeah.
my mind is full of stuff, so today it's going to be books I've read, and tomorrow it'll be theater, and Thursday I'll do
All
Italy, and Friday I'll do a trial.
Yeah. Well, you could have like multiple channels then, one
Oh,
about, my visits to Italy, because
ah,
some people love those types of travel channels,
yeah.
where people
Uh-huh.
are kind of showing, like, you could do like Italy on a budget. I
Yeah.
think that
You're
could
going to
be a
have to be
nice
my
niche.
agent, Judy.
Yeah. I'll come up with ideas, because if my voice lasts, I would like to do some sort of 5 years on YouTube celebration live
Ah,
stream, where I give people advice on how to grow a YouTube channel, or just my tips on,
I
how to
see.
live stream or how to get
I
more
tell you what,
subscribers.
you
Yeah.
can practice on me.
Okay.
You can do it all, obviously, often. So then when you do it for everyone else, you'll be even better.
Yeah. Well, I don't want to make people feel bad if I criticize their channels or something. I'll have to say very general things, like,
Now,
just
everybody
in
who's still on
general.
this chat, note that I said that practicing lawyers are very polite and very courteous. It's the academic lawyers who are more blunt. There's an
Oh.
example. A very kind, and not suggesting Judy's insincere at all, because I know she's very sincere, but it's a different way of approaching people and issues.
Hmm.
And
Yeah.
we get along with each other as law professors, but we're kind of, an interesting menu item for a lot of people. Luckily, I'm in New Jersey. The New York metropolitan area is another area where there are lots of people here who are an interesting menu item. So I consider myself a threefer, because I'm from this area, and I'm a lawyer or law professor, and I'm an Italian. So you put all three together and, you know.
Okay. Well, getting back to Dan Markel, you've heard those stories that people said that Dan liked to push people, and he
Exactly.
did like to have healthy arguments and
Exactly.
debate, and push people on their ideas and question
Exactly.
them and stuff. So
Exactly.
do you kind of identify with that aspect of Dan
Absolutely.
Markel? Yeah,
Absolutely. Yeah.
yeah. Okay, so getting back to the chat and Donna Adelson's case, does anyone know how the Saul came to the attention of the defense? Apparently, they weren't told initially.
Yeah. The prosecution has to give over in discovery at some point. So I got the dates somewhere. I wrote all these dates down so I could,
Yeah, I think it
keep.
was April, because in this
Yeah.
brief, they said they started getting
Yeah.
getting the information in
Right.
early
April
April.
7th, they gave a flash drive of the January 10th warrant. That was the pen register warrant. And then on April 10th, the state gave the discovery on the application and the affidavit for the original warrant that issued in December. That was the one for the, communications on Harvey's phone. That is the phone list. So, and then it was on April 11th, they got a little more discovery on this. Somewhere in there, they also got the information about the wiretap, and I think they got that information maybe as they were doing the motion to disqualify Judge Everett, and then they did the amended motion to disqualify Judge Everett. So as a general rule, Tennis Girl 101, when the state has something that's arguably relevant to a criminal prosecution, they're obliged to turn it over to the defense. There's no, let me surprise you into something at trial. You're supposed to know it so that you can prepare.
Mhm. Okay. I think we touched on this before. What happens to Donna's lawyers if it's proven that they helped Harvey? Wouldn't
Yeah.
that be a severe situation where they could have their licenses
Yeah,
in
it depends
jeopardy?
on, I don't know. It depends on what the information is that helped him. I mean, they're not his lawyers right now. So they'd be operating theoretically the way you or I could, Judy, in terms of helping somebody out there who may be prosecuted. Now, their situation is obviously different because they're representing a co-conspirator, because Harvey's been listed as a co-conspirator. I wouldn't want to try to do too much without looking at some case law and trying to sit down and work out, what exactly might have happened. And I still think we need to know much more about what actually can be proved that they did. And we just don't know. Yeah.
Jumping around in the chat, what illness did Fulford claim to have to circumvent her ethics hearing? That's what I don't know, but it
I
is very
believe it was
strange.
cancer, but I
Really?
think I had heard someone say that it was cancer. And I'm not saying she only claimed it and didn't have it. I mean, but that was I believe, the illness that she told the court, and then the ethics complaint was dismissed because she was no longer a judge, and the ethics complaint went to whether she would be sanctioned in some way, because the allegation was it offended the judicial code of misconduct.
Okay. Do you recall where you heard the cancer
I'm
reason?
gonna guess Tim Jansen somewhere along the line, but it's a guess as to where. But I'm pretty
Okay.
sure I heard it. I don't think, I'm pretty sure I heard it. And I think it might have been Tim at some point. Actually, it might have been Tim the other night. Could it have been on that STS?
Oh, okay. Well, sometimes I'm not totally
Yeah.
listening to every single word, or I fast forward through
Yeah.
some parts. But interesting, because I could have sworn I saw an article online where they said she had a permanent disability. So I was like, well, what is this permanent disability? Because obviously she still has her law license and now she's taking on a case again.
Yeah.
So
I don't
who
know.
knows?
We'll have to watch that FCS show again, because I think maybe
And
that's
we'll
where I
give them
heard it.
more views. Yeah, I'll watch
That's
all
right.
the commercials out there, guys. Yeah, supporting the channel. Okay, so let's look at this. Hi, Vegas. In previous hearings, Fulford emphatically said unless they get extensions, they absolutely cannot be ready for trial. It sounded more like a threat. Do judges always give in to that?
No. But in some ways, it depends on the reasons why they're asking for the extensions. And you recall, they got an extension of time a few weeks ago because they said it was only then that they got those 100,000 emails or texts or phone calls, whatever they were, that the taint lawyers had to go through. And then they got some of this information later. So they were pointing to things that they didn't have when the original trial date was set. If they simply said they needed an extension of time and nothing new had happened, it would be much more unlikely that a judge would grant it. And it also depends on the judge. Some judges are, more willing to grant an extension of time than other judges. Some judges hold you to the schedule, and I do think that from what I've seen of Judge Everett, he's one of those that holds holds your feet to the fire unless you can show something, that really means that you were doing your due diligence and still you couldn't, get ready for trial. I'm told, but I don't have personal experience of this, that in federal court, the federal judges tend to really hold you to the schedule, and they aren't willing to hear, your claims that you need more time.
Yeah, I'm hardly ever in federal court, but I do like how it seems to run like clockwork.
Yeah.
It does seem to be like a lot more efficient.
Yeah.
They stick to the deadlines.
Yeah.
Yeah. Okay. Other than undercover law enforcement, can a witness on the stand ever hide their identity in criminal cases? Well, actually, Jessica, who was Luis Rivera's daughter's mother, she was able to testify without being shown on the live stream.
Yeah, I mean, I assume you don't mean something like COVID where somebody would come in or having a medical reason. I don't know that I've ever seen somebody testify in a mask, because you would think that would have an impact on the jury. But I assume it is possible, and certainly with some witnesses, they don't necessarily testify on the stand. Child witnesses, for example, are sometimes in another room and they're on the screen, but they're not present in the courtroom when they testify. I've testified in a couple of NCAA cases as an expert witness, and mine was a deposition that was up on the screen, so I wasn't there. So there are times when a witness is not in court testifying, and I assume in that world out there, there are times when a witness might testify with a mask, but I can't think of any.
Thank you. Let's see. So many comments out here. I just noticed you haven't taken a drink of water. Like, do you ever get tired from
I
talking?
did. Here's the glass. I finished it.
I guess I didn't pay attention because I feel like I'm constantly grabbing for my throat coat tea. So, yeah. Let's see here. Andrew says, hello. Doesn't the way Donna is behaving and all the emotions make you think Daniel Rashbaum did a good job at managing Donna? I don't think so, because it could be that her attorneys just think that this is a good tactic, that they want to pull out all the stops. So it's not necessarily Donna telling them, file this motion. What do you think?
Yeah, I think, Judy, I think that's certainly a possibility. And I also think the other possibility is that they're more likely to just do what she wants. Or she's less likely to trust them when they give her advice, because remember, she just thought Dan Washbaum walked on water. And it easily could be true that when he gave her advice, since she thought so highly of him and had so much confidence in him, that she agreed, and that these two lawyers, she just doesn't have the same relationship or confidence in, and therefore is pushier than she was with Daniel.
When
But
you were
the observation is correct. I mean, there's certainly much more going on in terms of paper flying everywhere.
and hiring an appellate attorney already.
Yeah.
That's unusual.
Yeah. I mean, it's not a bad idea if you have all the money in the world to have the appellate lawyer there and, even at the trial, to advise, because the appellate lawyer can keep a really good eye on what might be appealable issues and what needs to be raised and when it needs to be raised. Trial lawyers are supposed to do that. Clearly, they should be looking in both directions. But, at trial, there are a lot of things going on, and that ability to keep an eye on what the record needs to look at on appeal is much harder than if you have somebody there tasked with it. So, if anybody out there intends to commit a crime and has a lot of money, it's a good idea to have an appellate lawyer, there sitting.
That's right. And remember, Tara Kawasa's sister was there during Katie McDaniel's trial, but she ended up not being the appellate attorney.
Right.
But I'm sure she had to be paid to sit there the whole time.
Yeah.
And I did hear someone say that Offerman, Charlie's appellate attorney, was also there during the trial. I don't
remember that. Yeah.
Yeah.
I don't remember seeing him, not that I would have, no, I don't remember anybody pointing him out there, and I certainly don't recall anyone ever talking about it, so.
Yeah, it's just something that I remember. Maybe someone said it in passing on STS or
It wasn't on
something.
STS 2 nights ago?
Oh, no, it could have been like 2 years ago during Charlie's trial. Well, year and a half-ish ago. Let's see. Judge Everett has got to be sick of it. No, I mean, that's his job, right?
It is
Like,
his
how
job,
can he
yeah.
get sick of somebody's case because there's just like tons of other cases he has to handle in a professional way.
Right.
So, okay. Hi, Wesley. What happened with all that new discovery in relation to all the emails? They found it seems to be an afterthought now. Well, I mean, we just have to wait till the trial to see what out of those emails what gets used.
Didn't they say that there didn't Sarah say that there were only, what'd she say, 5 or 6 that they intended to use at Donna's trial? It was a very small number that she said
Okay.
they were actually going to
I can't
use.
remember. See, you
Yeah.
have better memory than I do. I remember that they did say they were just using a couple of those.
Right. I
new-
thought it was when
Yeah,
it
maybe
was when they
that's
were having the argument on all the emails, and she was claiming they could still make the date because, they had looked and the investigators said there were maybe it wasn't even 5 or 6 that were going to be relevant to the trial. So my
Oh,
number
okay.
5 or
Yeah.
6 might be wrong, but it was certainly
Okay.
that or
Yeah,
lower.
maybe I do recall that. But, as you know, the defense still has to weed through all this stuff. And that's what Zellman was talking about, that they were so overwhelmed with all these emails and they were trying to use software or something, some
Yeah, did you follow? I
services.
didn't understand that. I mean, you as the lawyer can't rely on AI or anything else. Yeah, I see that. Yeah. I have flowers behind me. Nobody's mentioning that observation
They're
station.
beautiful. Yeah,
Thank you.
but she's the one who is the artist. So I bought
Oh, I
this.
didn't
I
know
bought this
that.
from
It's
her.
very pretty. Yeah.
Yeah, it's
Yeah,
gorgeous.
very nice. Yeah.
Yeah. Check her
So
out. Her Instagram is
I will.
Jetty
I will.
May on
Uh,
Instagram.
so
Jetti. Okay.
Jeti
Jetti
TTI
underscore May MAE. So
Okay.
that's her on Instagram. So feel free to put that in the chat observation if you want people to see your beautiful
Yeah.
paintings. Yeah. Okay. I'm sorry to interrupt.
That's
What
all
were
right.
you
I
saying
lost my
about the
train of thought.
emails?
Couldn't have been that important.
No, you said that the emails that you recall Sarah Dugan saying they were only going to potentially use 5 or 6 of those new
Oh, I know. I was
emails.
talking about AI.
Yeah.
You can't rely on AI, obviously, and you can't rely on a legal assistant. And to some extent, you can't even rely on another lawyer who's not working on the case to be able to see that something in an email might be relevant or might be important. That's true. On the other hand, AI can be used to categorize and organize so that when you go in as a lawyer, it's much quicker. You don't have to go in and wade through and decide, what pile am I going to put it in? And it can save a fair amount of time. Uh, and I'm not sure how much time. I mean, the new emails that they got on the basis of the 2 wiretaps, emails or phone, whatever it was, the phone records, doesn't sound to me as though it needs to take that much longer. And they got the extension to look at those already. That's why they got this extension until August, whatever the trial date is now, from the June
19.
date. So they got 2 months. I could look through that many emails 5 times in 2 months.
Okay. Yeah, and I'm sure these attorneys don't have any other clients. I'm just assuming because Donna can pay them
I
big
think
bucks.
I would agree with you, except that I heard somewhere that who was it? I might have been Patty Playhouse. I was watching, I'm a night owl, and so at 3 in the morning, I will watch tapes of some of these things, and I caught her, and she said she had been in court when when Donna's lawyers got the extension of time, and she had watched Josh Zellman right before Donna's case. He was on another case, and according to her, he made the same claim that he was too busy and couldn't make the date. So he has at least one other case going, if she's accurate.
Oh, yeah. And he mentioned something about a family issue that came up.
Yeah, that
So,
I don't recall.
yeah. So, Well, okay, so I guess Donna's not paying him enough that he can clear his whole calendar just for her. So, yeah, I get the feeling she's not as close to him as she was with
Yeah.
Rashbaum or Jackie Fulford. Yeah. What about this? I don't know if you can answer this. How can we say no phones when I see inmates in prisons with iPads given to them by the jail?
Yeah, now you're talking to the no techie among us, but I think you can do something to an iPad to limit what can come in and what can go out. I don't know how they do it, but I think they can do something so you can't make a phone call, or I suppose if there's no, well, I shouldn't talk anymore. I think there's something they can do. And I'm sure there are people out in the chat who are, better able to explain the kinds of things they do. But that's why the iPad is provided by the prison. You can't just go buy your own iPad and use
Yeah.
it.
Yeah. And I'm not even sure. Is it an iPad? I've always just heard it being called a tablet. So it
Okay.
could be some cheapy, like a very restricted
Mm-hmm.
electronic device that they can use to watch some movies
Right.
or music or, just has limited, sort of like something you would buy for a kid.
Mm-hmm.
I'm assuming. Yeah. So, let's see. Wonder. Oh, Rosemary wants to know, are we going to read the motions? I think that would just take too long. So, but I did slowly scroll through it while we were talking, and it looks like we're not going to have time to look at Charlie's amazing appellate brief. But I totally agreed with all your comments on surviving the survivor. Was it about a week or so ago?
Mm-hmm.
You guys were talking about his appellate brief. And the first argument was ridiculous, where he's saying like, "Oh, the motion for change of venue should have been granted because of all these things people were saying during jury selection."
Mm-hmm. Mm-hmm.
Yeah. So that was so bogus because it's like, who cares that some people said these things? They didn't
Right.
get selected.
They didn't
What
get
do you-
selected and they weren't heard by the people who did sit, at least most of them. And it was unclear um, because the way that brief was written, again, unclear for the couple that might have heard something, what they heard, what they heard other people talking about. They could have talked about, we know there's a trial going on and we think it's a murder trial, as compared to, I know he's guilty and here's why. Yeah.
Okay.
There you go. Clarissa knows.
Thank you. Yeah, Clarissa has said in the chat that she worked in criminal law for 30 years. So thank you, Clarissa. She always has good comments. She says they do not have iPads. It's a simple tablet with pre or programmed movies and the ability to send text that they paid for. Has to go through the jail, each text, each call.
There
Okay.
you go.
Thanks. It's great to hear from people who actually
Know
know these
something.
things, work in the jail or know about criminal law in Florida. Okay, can't wait for Donna's jail costs. Yeah, well, someday maybe Mentor Lawyer will pay again to get a big batch of something, because it
Mhm.
is true. Some of those things you have to pay for because people who work for the state have to filter through all the info to make sure it's okay to give
Right.
out to the public. So even though it's supposed to be accessible, there could still be hundreds of dollars or
Mhm.
over $1,000 charged. Well, so I think this was a long time ago, but this was before Wendy's friend came forward. Joe, maybe that's why. Huh? Okay. I'm not
Wendy's
sure.
forward is Sarah Yusuf.
Yeah.
Yeah. But
And
what was that was, but I don't understand what the reference is to though.
yeah, maybe I'm so far behind, I probably have to scroll all the way down and see if this person is still
It
there.
might be, we were talking about why Donna now doesn't mind the delays and before she was pushing. So maybe it's the reference to that she was pushing before Wendy's friend came forward and now, she'd just as soon have it, not go to
Yeah.
trial quickly.
Yeah.
If I'm not
Well,
right, not the FBI, I think, I don't want to speak for Judy, but you'll have to let us know what this is.
mhm. Okay.
Look at
So
that.
caught
I have
in it.
this phone. I've never even thought about
Oh, isn't
making
that great?
calls out on it.
Yeah.
Huh.
Well, do you like having that Apple Watch? I don't
I
even have
love the
one.
Apple Watch.
Oh,
And one of the things I love about the Apple Watch is it can find the iPhone. It has a find the phone that if it would do a find the TV remote, I'd pay $1,000 for it, but it doesn't have that feature. Yeah, no,
okay.
I like it. I do.
Yeah. Okay. So, yes, it's August 19th. August
Right.
19th. Yeah. Let's see. What issues are being avoided when questioning Wendi on the stand? I know George is really strategic. They're trying to stay away from some issues because of her immunity. Well, that's a good question. I don't know. It is true that Kappelman has always been very calculated. So you would get these people in the comments
Right,
harping on Georgia Kappelman saying, well, why didn't she ask about this?
right,
Why didn't you grill her more? I'm like, because number one, it wasn't relevant to that person's case. And number two, because, they have to be careful as to what they draw out of Wendi. They don't want to
right.
give her some open-ended question when she's got that, what is it, use and derivative
Yeah,
immunity?
use and derivative use immunity. That's right. They want to be very careful. They don't want to ask open-ended questions. They don't want to ask her anything they don't need to get from her because every answer is potentially something that they're now going to have to explain that evidence they used didn't come from something she said. So the more limited they can be with her, the more they're going to try to be limited. But we don't know what it is, at least I don't, what it is they're avoiding asking her, what evidence they might have is, I don't know what other evidence they might have. Um, I suspect that if and when she testifies at Donna's trial, they will not ask her questions about Sarah Youssef. Although, no, I guess I take that back because they have the information about Sarah Youssef independent of anything Wendi said. So to the extent they think they got everything from Sarah Youssef that they can get, and they think Wendi's testimony will help convict Donna, they might ask her something about Sarah Youssef. But that's a good example of where derivative use immunity doesn't cover. Sarah came forward without any information coming from Wendi that she existed or that she might know something. So they're perfectly free to use against Wendi anything Sarah says.
Mhm. Yeah, and I recall Sarah was listed as a potential
Right,
witness for
right.
Donna's case. Yeah. So let's see here. In the lawyer community, will you all be able to sit down and have lunch with Dan Rashbaum, even though he's doing what he's doing? Like, do you all in the lawyer community blacklist lawyers? Like, no, I don't think he's being blacklisted in Florida at all because people realize that he was doing his job. He got paid to do a job. So it's nothing personal. Would you agree, Professor, that you don't think all the
Yeah,
lawyers in his community are shunning him?
yeah, and he's probably got friends and, colleagues in the legal community. And what he did was not, I mean, he didn't steal client funds or do anything like that. What he did was really ill-advised and showed poor judgment. And maybe it was sufficiently poor judgment that he might be sanctioned or disciplined by the bar in some way. But it wasn't anything that was dishonest or unethical, at least as I recall the claims against him. So I would doubt that they're not sitting down with him. Now, they may be, talking about how could he have done this? We wouldn't have done it and not say that to him, but I don't think they're shunning him.
Yeah, I think a lot of criminal defense attorneys, they sleep well at night because they feel that they're protecting the system. They're being wards of the justice system and fighting for their clients within the
Hmm.
parameter of the law. So, because a long time ago, I did work for a firm that did mostly criminal defense, but I did the civil work for them. So that's what they would say. It's like,
Hmm.
this is my role is to make sure the prosecution proves all the elements of the crime. So they don't feel bad because that's their job.
Mhm.
I don't know if you watch Kathy from Gossip, Rumor, and Innuendo,
No.
but she has this running joke where she's talking about how Dan Rashbaum is enjoying his beautiful mansion and he's taking a backstroke in the Adelson pool and eating his pizza on the outdoor Adelson wood-fired pizza oven. Or it's really funny, actually,
Yeah.
but
Yeah. I think if I were to, the criticism of him, one of them is he too much wanted to represent Donna, to be able to stand back and assess the potential conflict issues that might arise out of it. And I think it came out of, it might have been an economic motive that he was going to make a lot of money. It could easily have been the fact that they were close and he thought he could do the best job for her. But I think he was too close to be able to make a really informed, and reasonable judgment as to the risks.
yeah, especially if he's gotten so close to the point where he and his wife are having dinner with Donna
Yeah.
before she was arrested. I mean, that's kind of strange. Like, how often do lawyers and their spouses have dinner with a client? I've never done that.
Yeah.
Yeah. Oh, sorry if we missed some questions. I believe the complaint said phone/watch. So perhaps she was using the watch to call. Yeah.
I didn't
that's what-
notice that in the complaint, so that's a really good pickup. Bling is the new black. Yeah, we did talk about it a little. That I think that the claim was that maybe it was the phone, the watch, not the phone, which I said makes more sense because it's hard for me to see how you could get a phone in without the people at the jail knowing and stopping it.
Mhm. There were at least one bar complaint filed,
Mhm.
and it's all secret, so that's not going to be made public while it's going on.
Right.
So it's only if there's going to be some sort of published decision in the
Right.
future. Typically, it would show up on the bar website.
Right. And there's nothing yet.
Mhm.
So.
Oh yeah, gossip with Kathy. Yeah, it's Kathy with a K. But yeah, she has some really hilarious summaries of a bunch of different true crime cases. Yeah. But he lied to the judge. He pretended to have covered all the issues and he hadn't. Okay. So that's an issue with the state bar, I assume.
Yeah, and the question is going to be whether he, misstated or intentionally tried to deceive the judge. And I don't know that the evidence is entirely clear about that. He said that he had explained it to her, and I believe he said he had talked to Charlie. But I don't think before the judge he said everything was in writing. I'm not sure. I know he did say it on the air at STS. I'm not sure he said it to the judge. But if indeed they find that he lied to the judge, he's got a problem.
Mhm. Joel asked him straight out and he had some BS line.
Mhm.
Yeah. So. All right. How far are criminal defense attorneys allowed to go before they cross that perpetual gray line between unethical or illegal?
Well, Rosemary, the fact that they call it a gray line tells you that there's no firm place where you know when you've crossed it. And it's fact dependent. Each case is going to be different. I think a responsible criminal lawyer won't get so close to it that she risks falling over and doing something unethical. Um, when you've gone too far, and when you're well short of the line, but there can be some, sort of tricky issues when you're close because you do have an ethical obligation to, as a defense lawyer, to represent your clients to the best of your ability and vigorously. And so that obligation is going to take you as far as you can do within the, the realm of what's ethical. And you can make a mistake on the facts, there's so many places where you can be trying to do things correctly and still end up having done something that's over the line, which is why I say the responsible lawyer would try to stay a little short of it. But there's really no answer as to when you've gone over that line. In advance of a fact pattern. On a fact pattern, you can make a reasonable assessment as to whether or not it's going to be unethical or illegal to do it. And the bar in a state has courses on this and presentations on this, and they'll provide hypotheticals. The ABA does this every year. You get a hypothetical. Can you do A? Can you do B? Can you do C? Can you do D? And you'll find lawyers coming out, on each of the answers. Which is why they do those courses, to help people, get a better feel for where they should be. And I think all states, I know most states, if you don't know whether something is ethical or not, you can call, there'll be somebody in the bar who's assigned the job of discussing with you and help you work through whether what you're thinking about doing would be ethical or would be a problem.
Right. And of course, the attorney cannot knowingly have the client lie. So you can't
That's true.
knowingly lie in court.
Right.
But
And you can't put on perjured testimony.
Mhm.
Yeah.
Yeah. But if your client is telling you some sort of goofy story, you can believe them and argue for them.
Yeah. And there's, was it Rosemary who asked that question? I don't remember who there's a book, famous book, Anatomy of a Murder, which is all about how that defense lawyer managed not to know whether the client committed murder. And there's a speech that some lawyers give about, if you did this, then I'm going to have to do this. But if it was this, then maybe not. And I'm telling you this advance. Now tell me what you did in order to avoid absolute knowledge, at least as the client understands it. So I see misdemeanor OG says Rashbaum is sleeping a lot better than Dan. That's true, but let's be fair. Rashbaum didn't commit murder either.
Somebody wanted to know why we're seeing more of your ceiling. And I mean, we tried to address this before we went live, but she's not able to adjust her camera down even more.
Right.
But you know what, like, people can't see this, but a lot of times I have piles of books or a box or something where I pile up the boxes and books to get my laptop higher. Yeah. So that's something maybe you could try, because I
will.
guess.
Well, I'm not going to be using this much longer. I'm getting a new laptop. So this is the iPad that it's got a smaller screen. I think that has some of the reason why. Besides which, don't you think I have a lovely ceiling?
Yeah, your ceiling looks pretty cool. So,
thank you.
No cobwebs, no popcorn.
Well, you don't know
ceiling.
about that. You can't see whether they're cobwebs from the screen.
Oh, okay, that's true. That's what's great about live streaming. It kind of like evens out the wrinkles and the sunspots on my face and stuff. So yeah, let's see. How about here? We'll wrap things up soon. It's almost 2 hours, I know. If it turns out that Donna did use Zelman or Fulford's phone or watch, they get charged with a crime. Well, that is a crime in Florida, right? That's what Tim Jansen said.
That's what Tim Jansen said. It is a crime. And so if it turns out that the facts are that they did it, they can be charged with the crime. Yes.
Mm-hmm. Okay. Joe is an ethical person. Many lawyers aren't. Well, I'd like to think that most lawyers are ethical, but it's the bad ones that stick out and get heard about. But Rashbaum should have known better. Why didn't he? I think probably because the family just kept saying, yeah, we're all together. We're a team. We're a package. We stick together, and here's tons of money.
Right. And I also said and he said at one point that he thought of Donna as a second mother. When you get too close to a client, it's a bad place to be because you lose objectivity and you want so much to help this person that you're close to that it sometimes makes it more difficult to step away and make a reasonable judgment based on the information. And Judy is also correct uh, that, they were pushing him and he thought that Charlie and Donna, were just loyal to each other, and Charlie would never turn on Donna. So he, I'm sure, never really considered the possibility that what happened would happen. That is, that Charlie says, there was something wrong, and this trial can't go on with you. Thank you, Alaska. I mean, it's tough. And I think Judy's also right. There's also the money issue here. I mean, let's not pretend to be naive. You can do, you can do a zealous defense, and you can care about doing the best for a client, and you can care deeply about the system of justice, but you also want to pay the rent and be able to go on vacation.
You got to make a living when you're
That's right.
self-employed, especially. It's tough because you don't know if there's going to be like
Right.
lows in your
Right.
law practice
Right.
where you're struggling to pay the bills, high points and low points. Yeah. And Rashbaum has his own small law firm. So it's a business decision too, money.
Right.
Yeah.
And it has to be. You can't do anything for any client if you don't have you're not making enough money to, keep the shingle out.
Right. A lot of attorneys end up shutting down their practices and going back to work for, say, the government or some other firm because it's really hard to be self-employed. Yeah. Okay. Rosemary says, are defense attorneys trying a case allowed to ask advice of other lawyers before they make an error? Of course. Yeah, most of the time they're part of some sort of criminal defense bar. They have listservs for different practice areas. And you
They
have
have partners in the office, or if you're in the public defender's office, there are other public defenders. I always think, no matter what area of practice, it's very good to talk out something with another lawyer because, you may know a lot, but two people who are smart and thinking about something are always better than one person looking. The things that you just miss, or, an aspect of a case you just don't think about. So, yeah, I think lawyers who never consult are probably not doing the best job that they could for their client.
Yeah, there's always lots of different attorney organizations that people can join to get not even formal mentorship, but just getting together to talk or having lunches, continuing legal ed classes. So especially amongst the criminal defense bar, from what I've seen where I've practiced, there's a lot of camaraderie. Like people seem very friendly and helpful.
Right. And I thought during COVID at law schools, one of the really worst aspects of it was that the entering 1Ls didn't have the chance to interact and form, what were going to be professional relationships with other students because they didn't get to see them. And that's one of the things that law schools does, for lawyers, is it gets you working and meeting colleagues and meeting the people who are going to be the lawyers that you're going to be practicing with or against, and the judges who are going to be there. I mean, it's a really useful thing to be able to talk to others and ask questions of others.
Yeah. And it's good for attorneys to have that type of support because, unfortunately, sometimes people hate the criminal defense attorneys and make
That's
fun
true.
of them and, say that they're terrible, immoral people and stuff. And, it's kind of, or just a bunch of money grubbing ambulance chaser type people. And so it's tough to fight against that public perception.
You're absolutely right, Judy. And I guess I would say about defense lawyers also, the idea, sure, they take clients that are sometimes despicable. There's no other way around it. But just think about how difficult it is to represent somebody like that. I mean, it isn't as though a defense lawyer says, gee, these despicable people are the kind of people I'd like to have home for dinner tonight. I mean, they recognize that the client is, not an upstanding person and may have done really terrible things. So it's not as though, it's easy to represent them. And yeah, they're making money off of it. And certainly there's some that wouldn't care. But I think most of them genuinely, are not, are troubled by the fact that they're doing their representation. But it's also something that, and Judy said it really well, that they feel is their professional obligation.
Yeah, and they strongly believe in the Constitution and the law and the way that the prosecution has the burden of proof.
Right.
Yeah.
Right.
Okay, so maybe we'll wrap this up. It's getting a little hard to keep sitting on the edge of my sofa here and stuff, and I'm sure you want to get up and move around and stuff. It's kind of hard to keep sitting and live streaming nonstop, but it's gone by so quickly. Thank you, Professor Potuto.
Well, thank you for having me, and thank you for your guests for asking such great questions.
Yeah, it's great to have the chat here and so many good, interesting questions from people who know the case in and out. It's pretty amazing. So, yeah, but I still think, with those specific things you mentioned today, I think you would probably win the trivia contest. And next time, I noticed you didn't participate the last times we had trivia night. But maybe
better to think I would win than to try and know I couldn't,
Oh,
there's
still
some
get beaten
advantage
out
to
by
live in
someone like Sandra. Yeah. So, okay, well, great. Well, I think we'll go ahead and say goodbye to everybody now. Thank you guys so much for continuing to care about Dan Markel and getting justice. Somebody out there asked, how are Dan's parents doing? And I think they're still doing fine. They're holding up. They're still, as far as I know, relatively healthy and planning to be there at the trial. I know Joel from Surviving to Survivor keeps in touch with Dan's father. And, sometimes I keep in touch with Dan's mom also behind the scenes. So, as far as I know, they're okay, physically. So, yeah, thanks for caring. Okay, so we'll go ahead and say goodbye then. But
thanks,
Professor
Judy. You
Potuto,
are a terrific moderator. So do a great job. Thank you.
I'm glad my voice wasn't as low and
Your
shaky.
voice was great. I'm so glad.
Okay. Yeah. So I guess the Xeomin injections are finally taking effect in a good way.
Great.
Now that it's kind of worn down a little bit. Yeah.
Great. Yeah, it sounds great, and I'm glad for you.
Oh, Sandra said she would let you win.
And she was not one of the ones who asked what it means to be ethical, I guess.
Oh, I don't know. Yeah.
Thank you, Sandra.
Okay, well, have a great weekend, everybody.
Thank you.
It's so nice talking to you, Professor. Thank
Thanks.
you
Same here.
for your
Bye.
time. Take care.